Good morning to you all, and welcome to this panel session on arbitration and Africa. Africa and arbitration, is London still relevant? And at this point, I'd like to say a happy Eid to all the Muslim faithful who are celebrating today, or yesterday, as the case may have been. And I thank you all for joining us so early in the day on this on today's program. It means we get your attention before you jet off to join all the other panels. Over the next 45 minutes, we're going to be talking about the topic from the following perspectives. We'll look at the trend of rising nationalism around the world, see how it's shown up in Africa. Many African countries are urging for the resolution of African disputes by Africans on the African continent. Now, will this make London and its cost system less relevant to Africa in the years ahead? So we'll consider the role of the global arbitration community in this. Also, the English court's role in terms of enforcements where there are African disputes. And if London is to remain or will remain relevant, are the arbitral players in London placed to keep a pace with new growth frontiers in Africa? And if not, what should they be doing? And then we'll look back onto the African continent. Will South Africa's International Arbitration Act facilitate what Africans are looking for, which is the choice of African seats by disputants? And then we'll end by looking at what the opportunities are for African arbitrators in a virtual environment. Does it enhance African disputes on the African continent? And we'll look at the trends for disputes that would arise out of Africa's technology boom. We have a nice balance of panel members today. Two of us are based on the continent, and the other two are London-based, but they have significant African-related practices. I myself am based in Lagos and with ALEX. Daniel Wilmot is with Stewart's, off the continent, based in England. Nathan Searle, Hogan Lovells, he's also off the continent. And then we'll come back onto the continent and we'll end with Alon Mayerov, who's with Clyde and Co in South Africa. At this point, what I'd like to say is please, all questions, put them in the chat box. We will take questions at the end of the session so that we do not disturb the flow of conversation. So please feel free to post your questions in the Q&A. So let me kick off today's discussion. When you look at what's happening around the world, I think it's a given that nationalism is a rising trend. Start with the UK. The Brexit movement itself was based on the belief that the United Kingdom should free itself from the shackles of Europe and promote its own interests and govern itself and not be regulated from outside. Then you go to America. The America First movement. It was a direct appeal to American nationalism and self-pride. American jobs were meant to be for Americans, no exporting of American goods or American services abroad. Make America great again. And then even on the continent, the European continent, Angela Merkel's immigrants are welcome policy had a direct pushback in Germany from German citizens and German nationals. So I think it's not a surprise that African countries have caught the same bug. In the arbitration community, it's expressed as a desire that the export of African-based disputes to London and other places around the world should be stopped. African disputes should be resolved on the African continent. In addition to which, more Africans should be involved in the global arbitration community. How come non-Africans are being appointed to resolve African disputes? And these are things that have taken place, taken hold in so many African countries. What we have seen is an uptick in the number of arbitration centers being established in African countries. The prime suspects or the prime locations used to be South Africa, Cairo, Lagos, Kenya, Mauritius. But a recent study that came out of the School of Oriental and African Studies has shown that nearly every African country now has an arbitration center of some sort, some domestic, some claiming to be both domestic and international. But this is a clear expression of the desire that the export of African-based disputes to London should be stopped, and that if the reason for the export of African disputes was, well, where are we going to arbitrate those disputes? Then countries were busy setting up arbitration centers and equipping themselves to provide the facilities that would ensure that now that there's somewhere where you could go on the African continent. Apart from the sense of nationalism, is there a legitimate basis for African countries pushing to arbitrate African disputes in Africa? I think so, and I'll start with some statistics. The majority of arbitration disputes in Africa are energy and natural resources based, or from the infrastructure sector. They are disputes that arise out of the African continent and African products, the natural resources that abound on the continent. And then also, it's not in dispute that the cost of arbitration is a factor. Arbitration centers in Africa are generally less expensive than arbitration centers in London or arbitration centers outside the African continent. And that's because the cost of living on the African continent is definitely not comparable in terms of cost and expense with the cost of living abroad. Come down to basics. Within London, the London Court of International Arbitration, LCIA, is the foremost arbitral institution. If you go to their webpage, it says that it is, and I quote, it is, quote, delighted to report an all-time high of 444 referrals to the LCIA in 2020, with 407 arbitration cases fully administered by the LCIA pursuant to the LCIA rules. The remainder of referrals are cases administered pursuant to the UNCITRAL rules, appointment only, and fund holding cases or other forms of ADR. And these results amount to an increase of approximately 10% compared with 2019, which was at that time a record year. In 2019, the LCIA caseload shows that arbitrators were appointed from 100 parties in arbitrations came from 138 different countries. So that shows that there is a diverse profile of parties that choose the LCIA. However, 60% of the 81 appointments that were known to the LCIA in fund holding cases were British arbitrators. The remainder came from only 15 different countries. A few more statistics to lay the basis for this discussion. The SOAS study that I referred to in 2020, Arbitration in Africa, had 350 responses from individuals in 34 countries across Africa, Asia, Middle East, North America, and Europe. 83%, 289 of the respondents, had participated in arbitration in Africa over the 10-year reporting period, that's 2010 to 2020. The top 5 African countries that act as a seat for arbitration are South Africa, Nigeria, Egypt, Rwanda, and Cote d'Ivoire. And 88%, 307 of the respondents, said that they would recommend African arbitration centers. So this is the basis for that agitation. One last fact before I hand over. In 2016, the Pan-African Investment Code was drafted under the auspices of the African Union to assist African countries negotiating investment contracts and bilateral investment treaties. In addition to providing a definition of, a suggested definition of investment, the Pan-African Investment Code actually proposes that such disputes should be resolved using African arbitration centers and under the UNCITRAL rules. In 2019, the African Continental Free Trade Agreement, which would make the African continent a continent-wide free market, came into effect. And the investment protocol under the Continental Free Trade Agreement is now being negotiated. As part of that negotiation, African countries are using or proposing to use the Pan-African Investment Code to determine the terms of the investment agreement. Now, if that does work, it would then mean that after the investment proposal is implemented as part of the free trade agreement, then parties, African countries, would negotiate and would implement and would resolve disputes that arise out of investments under the free trade agreement on the African continent using African arbitration centers and under the arbitration rules. Now, if that happens, then obviously the relevance of London as an arbitration center for African disputes will shift, because more disputes will be arbitrated on the African continent. Having said that, I agree that arbitration is party-driven and by consensus, but to kick off this discussion, it is my view that sooner rather than later, London will not be as relevant as it is today in terms of African disputes. And I'm going to pass over to Daniel and see what he has to say. Daniel, over to you.
Thank you, Funke, and may I repeat and extend your welcome to everyone who's joined us this morning or this afternoon, or indeed this evening, depending on where you are, and thank you. So I'm going to pick up on some of the themes that Funke has excellently put into discussion. And the topic of the event, of course, is London still relevant to African arbitration? And underpinning Funke's thesis, her views, it is the notion that there is a growing trend of nationalism of arbitration on the continent. And so let's run with that theme. And I really wanted to share some thoughts on two questions within that context. The first, if that is right, and there is such growing nationalism, does London have a role actually in supporting that nationalism? Or are the two mutually exclusive? Second, if there is a role for London, how long will that role last? And in fact, can London as a centre keep a pace and maintain a competitive advantage in what is clearly an evolving world of arbitral dispute resolution? Now, I'm not here to provide all the answers. In fact, you may conclude at the end of this that I have no answers, and I wouldn't be surprised by that. And each perspective, I'm sure, generates a lively debate. But I just wanted to put in a few thoughts for everyone's consideration. And inevitably, given the limited time available, they will be high level. But let's see where we get to. So as to the first, does London have a role in supporting the assumed or presumed African arbitral nationalism movement, if I can call it that? Well, first, that rather assumes that it will happen, that there will be such a movement. And Funke has referred to a number of statistics with which I can't disagree, nor would I want to. I mean, it is plain that there is a growth in arbitration on the continent. You need only look at the statistical data of some of the largest institutions, both on continent and off continent, to show that year on year, arbitrations involving one or more African parties are on the increase. and more generally as a method of dispute resolution, I think the data and the analyses and surveys show that arbitration is increasing in popularity on the continent itself. But what about the notion of a growing nationalism in arbitration on the continent? African parties using African arbitrators, African rules, whatever the aspect may be. I mean, certainly in the Whiten case and Queen Mary survey of 2018, so a few years old now, those respondents who responded to the survey from the continent identified that the ICC and the LCIA were still the two top institutions from their perspectives. But I fully accept that data is now a little out of date. And Funke has referred to the SOAS survey of 2020, which clearly illustrates the suggested trend of arbitral nationalism. There has been growth at the leading African institutions, and I think that survey counted 91 arbitral centres now on the continent, and the proliferation of such centres might in and of itself prove the point. And as Funke has referred to, with the embedding of the African Free Trade Continental Agreement, I think we are set to see a growth in cross-border intra-African disputes. And so it may be a safe bet to assume that arbitration, indeed domestic arbitration, if I can call it that, will grow accordingly. And of course, there has always been something of an elasticity of geographic relationship between arbitral institutions and the users of them. So in that context, what roles might London adopt? I mean, there are the obvious ones. London will be and will always remain a source of arbitration practitioners, arbitrators, party-appointed support, whether that's experts, services, vendors, and indeed, of course, the arbitral institutions that are here. London will always be a seat available for selection, and the English courts will always be a venue where the jurisdiction is required, for example, for enforcement purposes. And so the question arises, to what extent would the arbitral nationalism we're talking about cut across those perhaps more obvious roles? For example, the role of enforcement will always remain, but might London as a source of people, in whatever guise that may be, nonetheless remain relevant? But might there also be some less obvious roles? Might London be and continue to be a source of best practice? And I have in mind there, for example, Tanzania's recent adoption of its national arbitration law, which was heavily framed on the UK Arbitration Act 1996. The institutions don't only service party requirements within a dispute, but they are also prolific sources of institutional guidance, which in turn frame soft law standards to a certain extent. Will London be a source of innovation? Certainly, we have seen that the institutional rules of some of the larger institutions, such as the LCA, for example, have framed what are termed innovations in arbitral rules. And certainly they have also heavily influenced, it seems to me, the rules of the African institutions on the continent. Many of the adoptions by the LCA, the ICC, have been replicated. And even the last couple of weeks, we have seen the task force led by Sir Geoffrey Voss handing down its report on suggested dispute resolution rules for crypto assets and distributed ledger related disputes. That is an example of London on the front foot in terms of innovation, which no doubt will influence beyond its borders. And lastly, I think London has a role as a source of wider support, an altruistic role perhaps. London has been heavily supportive in various initiatives involving the continent. To give two, the African Arbitration Academy's annual program of bringing lawyers to have an experience within large law firms is premised, is based in London and involves the heavy support of many London practitioners. The African Promise has some roots in London support. And I think there will always be a role of knowledge sharing, training, and indeed co-counselling on cases. So I think there are arguments to be made that London's role, to a certain extent, will remain. But at this juncture, I'm interested to hear what the audience thinks. And so Holly, if you can still hear me, I'd be delighted if you could launch the first poll that we have today and to see the audience's views. It's a big question with very simple answers. So no doubt the answers would be more nuanced if we had time to debate them, but I'm keen to see what our attendees here today think. So let's give it a few more seconds. If you haven't answered, please answer now or forever hold, I'm not sure it's your piece, but your clicking finger. And right, Holly, why don't we launch that? Let's see the results of that particular poll. Well, there we are. That's interesting. That is interesting indeed. That may be a sign of the present view. It'd be interesting to run that poll again in a few years' time. But thank you for that, Holly. So moving then on to the second aspect I wanted to just share some thoughts with is if London does have a role to play, and the audience seem to suggest, or at least a large majority of the audience seems to suggest that it may, how long will it retain that role? And in fact, can London retain a competitive advantage in the evolving world of arbitration? The question I have is, are we starting to witness a breakaway from the established norms and a shift towards more disruptive approaches to arbitration? I mean, it certainly seems clear to me that many of the complaints we hear about arbitration have existed for some time now. And to give one example, which actually touches upon a feature Funke raised in her discussion, I mean, since 2015, the Queen Mary and White and Case regular surveys have repeatedly identified cost as a major issue, and yet query whether arbitration practitioners, stakeholders in London at the very least, are actively and adequately engaging with that issue. I think there is a growing discussion around challenger arbitral centres rewriting the rules of dispute resolution. We have seen attempts to revolutionize rather than evolve, for example, the Prague rules challenging the IBA rules. And we've seen similar sorts of initiatives in the context of arbitration on the continent. For example, the African Union debated for a long time the appropriate dispute resolution mechanisms under the AFCFTA. Were the established norms appropriate going forward? We've seen the Association of Young Arbitrators protocol on virtual hearings in Africa be launched to great fanfare, and deservedly so. And we've even seen COVID-related initiatives such as the KDRI program, which I think had its genesis in Nigeria. Indeed, more generally, taking a slight step back, we've witnessed something of a technological revolution insofar as the continent can now point to market-leading infrastructure in various areas, such as the fintech space. And I know others on this panel will touch on that in due course, so I shan't say too much more, but what I would say is that I'm always struck when visiting, for example, Lagos, as to the developments in this regard. And that technological shift offers challenger centres an excellent disruptive platform potential. So will arbitral nationalism draw from the existing rules, practices and approaches set by established centres such as London, or will it spawn new ideas? As a result of Brexit, the UK has had to reassess its marketability on a global scale. The recent Lugano saga might suggest, I think fairly, that the English legal sector has perhaps rested on its laurels a little. The irony is English arbitration has a strong story to tell in the face of Brexit, and yet it seems to me too few stakeholders have taken on that PR campaign. So it rather begs the questions: will London's established approach become stale? Will it become out of touch? Will challenger institutions diverge from existing approaches in order to create a service that is more bespoke to the needs and culture of its users? Does London need to step out of its bubble and reassess its offering and USPs? So whilst I think right now London remains relevant to African arbitration, I don't think by any means it's a certainty going forward. And I do think the London market needs to reassess what it can offer and why. I'll stop there and I'll hand over to, I believe, Nathan, who will share some further perspectives.
Thanks, Dan. So I'm going to change gear a little and talk about the opportunities for arbitration practitioners in the technology sector. As Funke pointed out at the beginning, historically, we've seen the big areas of arbitration coming out of the continent as being natural resources and infrastructure. But is that going to be the way going forward? In July 2020, the African Private Equity and Venture Capital Association, AVCA, revealed that the African technology industry had attracted 1.4 billion in venture capital investments in 2019 alone. This represents a huge increase from the previous 5 years, where in 2014 it was only 400 million. So that's over $1 billion extra that was put in 2019. And we see that there's also been a 50% increase in the amount of foreign direct investment that's been reportedly channeled into Africa's software and IT sector. Over the first in the first 7 months of 2020. So it's clear that technology is booming in Africa. You only have to read the press to see the major technology companies making announcements, expanding their presence, setting up headquarters, seeing the real opportunity in Africa. As Dan's already said, Africa leads the way in terms of fintech. Mobile money has been widely adopted in Africa. It's bringing financial inclusiveness, and that technology it's a region where that's really been adopted a lot quicker than in other places, and is really leading the way. Africa is not constrained by the old copper infrastructure that we have in places like the UK, and is really able to leapfrog and to move forward in technology. So what does that mean for disputes? Starting with the two that Funke mentioned, in natural resources, it means we're starting to see, I think, a shift, and I think this will continue over the medium and long term, away from oil and gas and those natural resources and into battery minerals. So cobalt, lithium, those are all things that are needed for the batteries that are going to power today and tomorrow's electric vehicles and other electronic devices. So I think natural resources is here to stay, but there's going to be a bit of a shift away from the oil and gas sector and more into, I think, the mining and particularly the battery minerals, which have been neglected historically in the mining space as opposed to coal and gold and other commodities. Infrastructure, I think that we're going to, along with this technology boom, there is a need for technology infrastructure, be that mobile telephone towers, be that fiber optic investment, be that R&D investment in technology. So again, the infrastructure and the infrastructure to transport and support the technology supply chain is going to be critical. So I think, again, we're going to continue to see infrastructure disputes, but they're less likely, I think, to be offshore oil rig infrastructure and construction context and more in the technology space. Hogan Lovells recently did a survey of technology companies asking them about joint ventures, and the 61% said that they would be looking in the near term to do more joint ventures in emerging markets. So again, Africa is there, it's competing for technology investment, but it's very well placed as tech companies now look globally for where they see innovation. 2/3 of tech companies said that they would be looking at investing in new markets where they weren't currently present. So we can see global technology companies looking to expand. and 65% were looking to partner or get into collaborations with startups in order to capture that new innovative technology. So again, this is an area that is active in terms of partnerships, collaborations, mergers and acquisitions, and along with that, we all know comes disputes. So looking into the crystal ball and seeing what trends we're already starting to see filter through in terms of the types of disputes that we're seeing, what are technology companies falling out over? Collaboration and joint ventures and partnerships, are important to share the research and development costs, to capture innovations and to provide content for platforms. So joint ventures are ripe for disputes, whether that is planning ahead for the divorce and the separation where things don't work out well, the wooing stage, understanding who your partner is and what they have to offer. This can be particularly difficult in the technology space, where innovation is so important. With innovation, research and development comes risk. If it's not tested in the market, if you're not sure even if a market exists, these are the sorts of issues you need to think about. Will a technology that's working in Lagos be suited to a different environment, in South America or the US? How do you, as it were, kick the tires on new technology? In addition to understanding what you're getting, you're thinking about how the company is going to be managed. When you have a partnership between a larger company and a small innovative startup, culture clash can be an issue, and so you need to think about how that's going to happen, but also how the company is going to be managed going forward. And so that's particularly important in the technology space, where it's not a single commodity, but what's innovative today, you have to keep innovating and changing and moving in order to keep up with the trends. Some of us remember when apples were a big chunky white box on your desk. They're certainly not that today, and so that some really interesting there. We've seen supply chain. We know what's happening with microchips. You need to make sure that the supply chain works smoothly, and how you deal with disputes when that doesn't go to plan. And we know that there are factories in the UK at the moment, where the car lines are stopped because they haven't been able to get the microchips that they were hoping for. Outsourcing, IT and technology outsourcing is increasing. Again, because companies don't want to take all the innovation and the risk in-house, they're outsourcing. But do you know who you're outsourcing to? What happens if their cybersecurity systems aren't as secure as yours? And so that's also an area that we're seeing more disputes. I think that is going to continue. Technology transfer, be that African companies transferring their innovative technology overseas, or other investors transferring their technology to Africa. And often it's a bit of both, where parties are combining their technology. Are you getting what you expect? Does it do what it says? Are you receiving the knowledge that you expect, or is it just a black box? And if it is a black box and you integrate it into your technology, what happens when it doesn't work, or that company falls over in an insolvency? And so we're seeing some quite sophisticated escrow agreements, not for funds, but for software code in transactions, so that yeah, if something goes wrong, the lender or the partner can step in, get the software so as to be able to fix it. If the vendor is not able to comply with its obligations in that regard. So again, that level of complexity. You also see an interest from regulators and governments in ensuring that where technology is coming in, that it's not always a black box, that there is capacity building and technology transfer, so that they can benefit from that information sharing. Technology and telecoms is increasingly becoming a regulated area. Telecoms has always been regulated, but we see things like cryptocurrency. There's discussion in various jurisdictions as to the level of regulation. Fintech is regulated as well, and we see governments also looking at foreign direct investment laws, particularly where it's regarded as sensitive technology. And so those all create issues both of dealing with governments and the potential for regulatory action, and that may be alleged to be discriminatory, or it may not. And we know those issues of public policy can give much debate. It's also important in that connection where there's dealings between business and government that those are done in accordance with appropriate procurement laws, and we know that that can also give rise to disputes in relation to the way that licenses are procured. So that gives you a bit of a flavour for some of the disputes, some of the issues that we're seeing in the technology space, particularly in Africa, that are likely to go on and generate arbitration work for practitioners on the continent and more broadly further afield, because as we see, there's often technology maybe either brought onto the continent or taken off. So there's likely to be an international dimension, as well as what we've already talked about, the increasing free trade within the continent itself. And perhaps to wrap up, I just wanted to have a brief chat about how technology may affect arbitration and dispute resolution in this sector. I think there will be a move to online dispute resolution. We've already seen that in the context of domain names with WIPO, but again, if you're dealing with consumers, particularly, I think that we're going to see more online dispute resolution, and it moving more from just the virtual hearing to something more like WIPO, where you've got fixed fees, smaller issues, that how to deal with that volume. We've already seen organizations like LASIAC have been discussing their online dispute resolution and how they will do that, and we look forward to that when it's launched. And then I will just briefly mention virtual hearings. I know most people are sick and tired of hearing about them now, but one thing that they do, and this circles around to what Funke and Dan were saying earlier, is that they do present opportunities for African arbitrators. And the reason that I say that is that Africa benefits from sharing the common law heritage with London. There are fantastic lawyers in Africa and arbitration practitioners who have that understanding, who come from that common law background. And they sit in the same time zone as Europe and London and share half a day with the US. And that makes them much more attractive to parties to appoint in arbitrations than, say, my Antipodean colleagues in New Zealand or Australia, or even to some extent the common law colleagues in Canada, because it enables parties to have that full hearing day. And whilst one of the things with virtual hearings is that you can do them at any time of the day or night, we all appreciate that. And when it comes to the arbitrators, you don't want them sitting up at 2 or 3 a.m. in the morning. And so I think that's a short-term opportunity, again, that should be embraced by the arbitration community and by clients, to say, well, actually, we need to think about where the arbitrators are located in terms of time zones. And that makes African arbitrators a good choice for international disputes. And I'm now going to hand over to Alan, who's going to talk about one of the up-and-coming seats in Africa, in South Africa.
Nathan, thank you. Thanks for that. I could just mention, some of us still remember when apples were green or red, things that we used to eat once a day because the doctor told us to. Good morning, everyone. And it is a pleasure being on here today. And I wanted to thank everyone for the time and joining us today. As we've heard from everyone, there's a growing trend of nationalism on the continent, and a move to have African disputes moved and heard on the continent. And so on that theme, I'm going to speak about something more specific. And as Nathan mentioned, the up and coming center in South Africa. And given that South Africa has adopted a new International Arbitration Act, how will that facilitate parties to choose South Africa as a seat and Africa as a seat? Because many of the reasons that make South Africa an attractive seat for arbitration likewise make the rest of the African continent an attractive seat for arbitration. So I'm going to focus on 3 areas, just give a quick background as to how South Africa got this new International Arbitration Act. Then I'll walk through some of the more important aspects of the Act and mention the Arbitration Foundation of Southern Africa. And then just an overview, as I say, why South Africa and Africa are attractive arbitration venues. So just by way of some background, for many years, South Africa did lag behind other jurisdictions, both in Africa and globally, and in that they did not have a well-established arbitral regime. Since about 1997, South Africa has had discussions about introducing a international arbitral regime, and that didn't happen for 20 years. And so I think, as Funke mentioned, allied with this growth of nationalism on the continent, South Africa realized that it was time that we joined the modern world. And in fact, South African courts have long embraced South Africa as a hub for international arbitration. A Supreme Court of Appeal in 2015 said South African courts not only have a legal but a socio-economic and political duty to encourage the selection of South Africa as a venue for international arbitrations. International arbitrations in South Africa will not only foster our country amongst the nations of the world, as well as international trade, but will also bring about the influx of foreign spending to our country. So you can see how the courts in South Africa for a long time did push for South Africa to be an international arbitration hub. So that then all came to fruition in 2017 in December, when South Africa eventually adopted its new International Arbitration Act, which is a modern, internationally recognized international arbitration act. And I think that it really has been a game changer for South Africa, and has catapulted us really into the 21st century and has made us an important player on the continent. And so on that note, and now that I've mentioned that background, why do I say that it is a game changer? Well, firstly, the Act gives full effect to South Africa's obligations under the New York Convention. prior to coming into effect of the Act, South Africa's international arbitration regime was governed either by South Africa's Domestic Act, which was an act that went back to 1965, which was not only outdated, but also simply not suited for international arbitrations. And then the recognition and enforcement of foreign arbitral awards was governed by an act which went back to 1977, which of course is also outdated, and it didn't align with South Africa's objectives and commitment to the New York Convention, because it allowed courts a very wide discretion whether to recognize and enforce foreign arbitral awards. So as one can see, that was obviously not it's not something that was acceptable. So that legislation has been repealed. The Recognition and Enforcement of Foreign Arbitral Awards Act of 1977 has been repealed, and the international arbitrations are now governed by the International Act and no longer the Domestic Act. In addition, South Africa has also now adopted the model law into its act, and so the model law, the UNCITRAL model law, is now law in South Africa. And for those of you who are not familiar with the model law, it's an internationally recognized and accepted legislative framework within which international arbitrations are governed and resolved. So the model law is essentially the gold standard by which international arbitration regimes are measured, and that's now the cornerstone of South Africa's arbitration regime. And as I'll mention later, we can see that that is one of the pillars of the attractiveness of South Africa, in that it gives investors and foreign parties a lot of comfort and protection, and I'll deal with that a bit later. So just to deal with some of the more important provisions of the Act, I don't want to really spend too much time on it, but really the Act applies to all international commercial disputes. It applies to public bodies in South Africa. So if there's a dispute with a public body in South Africa, such as a government department or ESCOM, for example, the Act would be applicable. However, the Act isn't applicable to investor-state disputes. So any disputes in terms of BITs or investment disputes with the government is housed entirely under a different Act, the Protection of Investment Act. So that's just something to bear in mind. As for the rest of the Act, it follows quite closely the New York Convention and the model law when it comes to the grounds for recognition and enforcement of arbitration agreements or foreign arbitral awards. Section 16 of the Act requires that a foreign arbitration agreement and foreign arbitral award must be made, must be recognized and enforced. Section 16.3 provides that a foreign arbitral award must, on application, be made in order of court. Section 18 deals with very limited grounds upon which a court may refuse recognition and enforcement of foreign arbitral awards. I'm not going to go into that simply because there's not much time, but those grounds really to a large extent mirror the grounds in the New York Convention and Section 36 of and Article 36 of the model law. So that's really our Act, which, as you can see, is based on the model law, and it's a very progressive and modern Act. That's one side of the coin. The other side of the coin is, as we've mentioned, having good arbitral institutions. And I mentioned earlier the Arbitration Foundation of Southern Africa, and they've done a very good job in filling that gap in facilitating international arbitrations in South Africa. On the 1st of June, their new international arbitration rules are going to be published. And those rules are really excellent rules. They are modern, they're progressive, they are based on and incorporate a number of procedures in leading global institutions rules such as LCI and ICC. They deal with issues such as expedited procedures, early dismissal of claims, third-party funding, confidentiality and transparency, and so on. So those rules are really well suited to facilitate international arbitrations in South Africa. So then, just to finish off and mention some of the factors as to why South Africa, and by extension Africa, are growing in their popularity as arbitration venues on the continent. Well, firstly, certainly in South Africa, the South African courts, as I mentioned, endorse international arbitration. They are pro arbitration. The shift of South African courts has moved from a interventionist approach to really a supportive role, and they won't get involved unless they necessarily would have to, and only then again within the confines of the Act. South Africa itself has a well-established and well-developed judicial system and has strong and independent courts. So South African courts are really pro-arbitration. In addition to good courts, South Africa also has very experienced and well-qualified arbitrators who are well-suited to deal with and adjudicate on international disputes. As I mentioned, South Africa has also adopted the model law. And as I said, that provides a lot of comfort to investors, foreign parties who will arbitrate in South Africa, because they know that that arbitration will be governed by a well-established, globally accepted arbitration and administered, in South Africa by the model law. It provides familiarity and clarity of process and procedure. It will ensure that the process is neutral without any biased intervention from the courts, and it will assure parties that arbitration agreements and then foreign arbitral awards will be enforced in South Africa. Thirdly, South Africa and a lot of other African jurisdictions have a very well-developed infrastructure system, resources and logistical support. So South Africa has good five-star hotels. South Africa has modern airports. It has Gautrain in Johannesburg. It has well-established large arbitral institutions such as AFSA and other facilities that can cope with and support large international disputes. So that all provides support for parties arbitrating in South Africa. Another reason is, of course, South Africa, as we have, I think, Nathan mentioned earlier, geographically, from a geographical point of view, we're in a time zone that aligns with the Middle East and Europe. Traveling time for Middle East and Europe is much shorter, so that's all attractive to parties. And finally, as I think Funke mentioned, the costs of running arbitrations in South Africa are much cheaper than in other venues such as London. So as you can see, many of those factors that I've just mentioned are applicable to South Africa and other African jurisdictions. There are already well-established African arbitral centers, including Rwanda, Kenya, Lagos, Cairo, Mauritius, and we hope that South Africa will join them soon as being a well-established center. So then just to really wrap up, I think that it will take time until majority or all of the disputes in Africa are adjudicated in South Africa, and certainly in the short term or the medium term, London will have a remaining role to play. But it's hoped that in the long term, more and more arbitrations and disputes will be referred to South Africa and Africa as a whole, because we have the tools and we have all the necessary structures in place in order to be able to successfully adjudicate those international arbitrations. So thank you. I see we're running out of time, but I think, is there time for a quick Q&A session?
I think there might be, Alon, and actually I'm going to jump in and throw a question Funke's way, because one has come in and it's typically insightful from Marx Ikonbe. Good morning, Marx. And Funke, Marx's question is as follows. What are your thoughts on Africa adopting the international or transnational court system to make it more attractive as an arbitration center? And Marx gives some analogies by reference to the Dubai Financial Center Court or the Singapore International Commercial Court, where foreigners are allowed to be judges and advocates.
Interesting question. My personal view is horses for courses. The reason why the Dubai International Center was set up was obviously to attract work to the Middle East. The Dubai International Center has its own laws because it's based within a Sharia-based legal system. And so it's specific. It's a carve-out. It's not part of the legal system of the rest of Dubai. So I'm not sure whether in that respect, that really is what we need. Singapore also has its own system, specifically foreign judges, foreign arbitrators, works for Singapore. Africa is looking at an Africa investment court for purposes of trumping perhaps the proposed European investment court for Africa-based investments. I'm not 100% in support of any of those ideas. Why? Because I think Africa, one, we are a continent. We're 55 different countries. We have different legal systems. There's common law, there's the Napoleonic Code. South Africa has a sort of a mixed regime. There are other countries that are French-based. And so it'll be quite difficult for us all to come together and agree to have one particular court based with either foreign judges or allowing foreign judges and foreign advocates. I think that a rising tide lifts all ships. And therefore, what each African country needs to do is to develop its own legal framework to ensure that it is robust enough to attract the confidence of the international community such that it is selected as a seat for arbitration. And since Daniel has thrown that question at me, I think I have a few minutes to throw one back at you. It seems that the consensus on the panel is that London will be relevant for some time to come, but perhaps it may need to shift its focus. My question is London doing enough to PR itself as a venue for arbitration, one, in the light of all these other venues coming up, and secondly, to PR itself for the alternative, the alternative positions that you have postulated, best practices, learning place, and things like that.
Thank you, Funke. I should have known that firing a question at you would get one in return. Actually, though, fortuitously, I had planned a second poll, which I ran out of time to run, but I'm going to run that in parallel to answering the question. So Holly, could you run poll number 2? Because actually it's almost on the question you've asked, Funke, and we'll see what the audience thinks in parallel. But whilst they use their clicking fingers, my feeling is no, actually. And as I said, I think, it presents a real opportunity for institutions and stakeholders in Africa to steal a march and disrupt. I mean, I should be absolutely clear. I think it's quite right that there is a measure of arbitral nationalism, if we can call it that. I think particularly given many of the challenges that we're still only starting to tackle, diversity of arbitrators, equal opportunities as counsel. But I do think London needs to reflect. It needs to be more proactive in extolling its position as a center of arbitration. It needs to identify what are its USPs going forward, what role does it wish to adopt. And I mean, I think we are clearly seeing Singapore reap the rewards from years of investment in the space. I think the latest White & Case Queen Mary survey identified Singapore now being ranked alongside London as the most popular arbitral seat, and the SIAC institution is now the second most popular institution. So I do think that there is more that needs to be done, but let's see if the audience agree. Holly, would you mind putting up the results? Well, there we are. At least there are some people who align with me. 68% feel that more needs to be done. Thank you. But I think that brings us out of time, doesn't it?
Yes, I think so. So I think we need to just say thank you to everyone who has joined this session. I hope that we have engaged you, and we leave you to go off and join the other sessions. Have a good day, everyone. Enjoy the rest of the London International Week, Disputes Week.
Thank you, everyone.